This is file 20382DM. It's Joseph Kitzinger versus Michaela Kitzinger. And there's a couple different issues we are addressing this morning. The first was the motion filed by Ms. Storm on behalf of Michaela Kitzinger. This was a motion, verified motion for order to show cause with proposed order to show cause and notice of hearing with remote participation. The hearing was actually held on August 8th of 2022, and I've been perhaps sitting on this too long, but I did actually finally get to it. And in the verified motion, the defendant had argued that the judgment of divorce, which was entered February 3rd of 2021, provided that the plaintiff was to pay $29,000 to defendant on or about December 31st, 2021, and that did not occur. And she argued that we came back to court on March 18th on an enforcement motion, and on April 6th that this court granted defendants money judgment and judgment lien. And it was indicated, we gave 60 days for the defendant. Paragraph 2 provides the April 6 order provided that the lien and money judgment could not be collected until a minimum of 60 days had passed the entry of the order. So it's June 6, 2022 at the earliest. The April 6 order also ordered plaintiff pay $5,000 to defendant's counsel to be held in trust pending resolution of the other motions that were pending before the friend of the court, due to plaintiff raising an oral request for consideration of his own attorney fees and costs as they related to his pending motions. And it says here, plaintiff has failed to comply with the April 6th order, and by extension, the judgment of divorce, by failing to pay the partial payment of $5,000 to be held in trust, nor has he paid the $29,000. Now, he did end up making some type of payment, but he reduced, I think he hand delivered $8,504 to Ms. Storm's office, but he was trying to claim a set-off for attorney fees. And that was the basis for the whole argument. I've gone back and listened to the arguments again on August 8th, and Mr. Kitzinger was of the opinion that because both parties had raised the issue of attorney fees, they were both entitled to them, and that he was somehow deducting it from the amount he was to pay the defendant through counsel. So I made it clear at the hearing that that was not the case, that he owed the money, and he had indicated that it would be paid by the end of that week. So the end of the week from August 8, 2022, he assured the court and Ms. Storm that he would be bringing in the funds to her office. I am unaware of whether or not that occurred. And I also explained to him what had happened is the court had said that it could not make a decision regarding attorney fees with respect to the case in chief, and that those would be sent down to the friend of the court along with the other issues for consideration, and that after that it could come back to this court for further consideration. And so Ms. Storm argued that I believe I've got this right, that everybody walked away from that by resolution of the friend of the court, and she argued that it was not preserved by Mr. Kitzinger's objection. Number one, his objection, she says, did not comply with the provision at the end of the referee's recommendation, which says an objection must include a clear and concise statement of the specific findings or application of law to which an objection is made. None of that was included in his objection. So at this point, I would agree with her. The issue wasn't identified. There may be other issues with the attorney fees that perhaps I'm unaware of, but it would appear to me that it was not addressed at the friend of the court as I had sent it there, and which suggests to me that neither party made it an issue. So making it an issue now, I find is not appropriate, that they walked away from it by disregarding the fact that I had sent it there. With respect to Ms. Storm's argument that she is entitled to attorney fees for her efforts in filing the motion in order to show cause, I accept her arguments that were made. She did not request a specific amount, and so I am going to order at this time that Mr. Kitzinger pay the office, pay defendant through the office of Marcoux Law PC attorney fees in the amount of $500. This amount is intended to compensate plaintiff for the filing of the motion and attending the virtual hearing on August 8th. These are not attorney fees related to work done prior to that. It is solely related to having to file a motion that should not have been filed. Mr. Kitzinger is to pay these amounts, this amount, within 30 days of entry of the order, which I will prepare. With respect to Mr. Kitzinger's objection to the recommended order, it is dismissed as not complying with the terms, and so I will indicate for the record the order for friend of the court services sending this matter down to the friend of the court also refers to the proper way to object. And again, there's a few different things that are required of an objecting party, but one of the main things is an objection must include a clear and concise statement of the specific findings or application of law to which an objection is made. The objection filed by Mr. Kitzinger doesn't give any specifics. It says, I don't agree with factors, basis of mother, if child is allowed to change schools, divorce decree states father has to, I can't tell what the, approve change of school, change of jurisdiction, once child allowed into different country, father has moved to have change of 50-50. I don't understand completely what he's saying, but he does not have any reference to specific findings or application of law objected to here. It appears what he's objecting to is the actual ruling or the conclusion. So he has not complied with the directions that were set forth in two separate locations, and therefore his objection is denied and dismissed. And again, I will provide the order for both of these.